Hello, everyone. Today, we will discuss a fascinating aspect of contract law, excuses and termination. I focus on mistake and warranty, particularly illustrated through the matter of Ponzi scheme. I will analyze the intriguing legal disputes between Laura and Stephen during their divorce. This case offers a unique perspective on how large-scale frauds impact individual contractual agreements. Banner a matter of Ponzi scheme, one of the largest financial frauds in history, disrupted countless lives, including that of Laura and Stephen. In their divorce proceedings, they found themselves locked in a debate over an investment account entangling in matter of web of deceit. The question is whether the revelation of the Ponzi scheme invalidates their personal contract regarding this account. Let's examine their contrasting views on the agreement's validity and how the scheme's discovery influenced their perception of the contract. Laura's stance is clear. There was no mistake about the investment account. It existed and transactions were made before the scandal's explosion. She highlights that the known risks of Madoff, opaque, and high-return investments were part of the agreement. As a sophisticated transactional lawyer, Stephen, she argues, knowingly accepted these inherent risks. Thus, Laura asserts that any claims of mutual mistake are unfounded because of the risks, though not fully understood, or part of the agreement unconsciously accepted by both parties. In sharp contrast, Stephen views their situation through the lens of mutual mistake. He argues that the investment account, integral to Madoff Ponzi scheme, fundamentally differed from their beliefs. He emphasized that they, along with the world's most savvy investors, were deceived, making it impossible for them to accept the risks associated with the investment knowingly. Stephen argues that this deception significantly altered the nature of their agreement, rendering it a case of a mutual mistake, as neither party was aware of the true nature of the account. To comprehend this dispute, let's explore mutual mistake and warranty in contract law. The concept of mutual mistake involves both parties being mistaken about a fundamental aspect of their agreement, potentially rendering it voidable. Warranty refers to assurance about a product or service's quality or nature. Historical cases, such as the sale of the supposedly barren cow and the transaction involving fake Stradivarius violins, shed light on these concepts. These examples demonstrate how mutual mistake and warranty have been historically interpreted and applied, providing a framework for understanding the complexities of Laura and Stephen's case. The court ultimately sided with Laura, basing its decision on several crucial factors. Notably, the language of their agreement did not specifically mention the Madoff account, which weakened Stephen's argument about a mutual mistake being integral to their deal. Additionally, the doctrine of mutual mistake requires that the mistake exists at the time of the contract formation. In this case, the account was optional and held value for a period post-agreement, which does not align with the criteria for mutual mistake. This ruling illustrates the delicate balance in contract law between the literal terms of an agreement and the broader context and intentions at its formation. To conclude, the matter of scheme and its implication in Laura and Stephen's case offer insights into mutual mistakes and warranty in contract law. It highlights the critical importance of contract formation's specific terms and context. This case serves as a powerful reminder of the need for careful consideration of all aspects of our contracts, such as the explicit and implicit aspects of the agreements. It also illustrates how legal principles adapt to unique and unforeseen circumstances. That's my part. Thank you.
Hi, my name is Anwen. This case is impossibility and force majeure. Donald Trump. Donald Trump, facing financial challenges during the Great Recession, borrowed $640 million from Deutsche Bank for a project. However, he encountered difficulties repaying the loan due to a significant shortfall caused by the economic downturn. Trump argued that the recession made a force majeure or an act of God, which could excuse him from promote monthly payments. Despite Trump's arguments, the court held that he was not excused from his repayment obligations under the force majeure clause and in his loan argument. The legal discussion explores the concepts of force majeure, the principles of impossibility and impracticability in contract law, as well as the importance of explicit contractual provisions such as force majeure clauses. Despite receiving accommodations from Deutsche Bank, the case highlights the challenges faced by individuals and businesses during financial crises and the varying treatment based on the schedule of financial transactions. This case is infancy Craig Trailer of Malcolm in the Middle. Actor Craig Trailer, known for his role in Malcolm in the Middle, entered a management contract with Shire Burger when he was just 10 years old. The contract, signed by Trailer's mother, obligated him to pay a 50% commission on his acting earning to Burger for 3 years. However, facing financial challenges, Trailer's mother attempted to cancel the agreement in 2001, leading to a legal dispute. The infancy doctrine is a way for someone less than 18 years old of age to escape contractual obligations. For centuries, judges have been willing to void minors' contracts to protect them. Burger sets various exceptions. Trailer's mother was an adult and agreed to the contract. Parents can discipline their children. Minors are prohibited from dating contracts involving the provision of goods and services necessary for the services necessary for the survival of the children, but the court rejected her claims. The case highlights the importance of considering the infancy doctrine in contracts involving minors and their need for parties.
Hello everyone, this is Meiting Wang, and today I will give you a speech about excuse and termination. And my case is case D and case E. And this is my main content. The first, I will give the summarize about the case D, and the second is case E, and the third is my reflection. The first case is AIG's employees' bonuses. The AIG is a financial company that provides complicated financial services. AIG was supported by American government, and it can get a lot of money from the government. And one day, the AIG gave its employees 165 million bonuses because they have the bad operation situation. Through this way, they can retain their employees. And this behavior lightens the anger of people. The AIG want to prove themselves to the society. So the company assert that these employee bonuses contracts were ironclad agreements obligating it to make the full payments. But the AIG statements have some weaknesses. For example, their statements don't give the explanation about the constructive dismissal, and giving the bonuses and using this way to retain their employees is also the fraudulent things. So many people refuse to trust them. And the case 2 is about the New York Mets and the City Field. It's about the Mets searching for corporate partners, and the City is their best choices. It's their best choice, and the City won the bet and signed a 20 years deal in exchange for paying the 20 million a year. The figures part outstretched in the Congress because the 20 million is a little bit a larger figure. And it affects the interest and the competition in the society. But actually, their cooperation has some advantages. Especially, they push the education development and push the society revolution. Because their cooperation break down the color because their cooperation by the color barriers, especially in the physical education. And my reflection is, in the company, our contract should be transparency, and also we should respect the rule of law, and we should compliance with contract. And the contract maybe have some different situations. For example, one of the parts, they don't have the ability to take the to take the responsibility for this outcome. So the contract should terminate in a good way. And
My name is Wang Rui. I'm from Group 3. My part is the case analysis of Part F and the conclusion. There are two cases of Case F. The one is Princeton University and the Robeson Foundation. Let's begin with the background. In 1961, Charles and Marie Robson donated $35 million to Princeton University to educate graduate students for government careers. The endowment grew substantially over the years. Dispute. In 2002, the Robson family objected to the university's use of funds for purposes beyond government career training at the Wilson School and filed a lawsuit. Resolution. After 6 years of legal dispute, the parties settled. The Robson Foundation was dissolved and $50 million was redirected to an independent Robson Foundation for Government. And the case 2 is Avery Fisher Hall and Lincoln Center. Background. In 1973, Avery Fisher donated $10.5 million to renovate New York City's Philharmonic Hall, and the pledge agreement included perpetual naming rights. Dispute. In 2002, Fisher family objected to Lincoln Center's plan to offer naming rights again during renovations, leading to scaled-back renovations plans. Resolution. 10 years later, after improved relations, a deal was reached. Lincoln Center paid the Fisher family $15 million and offered inducement. Fisher's family agreed to relinquish naming rights. And the case analysis of Part F. Scene. Both cases involved conflicts arising from dollar intent and the interpretation of pledge agreement. Legal dispute. The Princeton case settled after 6 years of legal battles with substantial legal fees. The Avery Fisher Hall case took a decade to resolve. Conflict. There's tension between donors' specific intentions and institutions' border lies in both cases. The two cases teach us a lesson that this case highlights the challenges of managing significant philanthropic donations and emphasize the importance of careful consideration of donor intent and effective communication. The last part, conclusion, and I will conclude all 6 cases with the most important words. Case A. It highlights the critical importance of contract formation's specific terms and context. The case serves as a powerful reminder of the need for careful consideration of all aspects of our contracts, such as the explicit and implicit aspects of the agreement. It also illustrates how legal principles adapt to unique and unforeseen circumstances. Case B. Legal analysis highlights the narrowness of excuse based on changing circumstances and the importance of contractual terms in the allocation of risk. This case highlights the challenge faced by individuals and businesses during the financial crisis and the different treatment based on the size of financial transactions. Case C. Since minors are a group that needs protection, there will be some risk when signing a contract with them. The case highlighted the importance of considering the doctrine in contracts involving minors and the need for parties to be aware of relevant statutes that may impact the enforceability of such contracts. Case D. It shows that the contracts can result the social reflection. The terms should be very reasonable and accurate. Besides, the contract shouldn't have the fraudulent. The company shouldn't use the fraudulent contract as a weapon to reach some purpose. Case E. Each part of the contract, their situations is different. Sometimes one of the parts don't have the ability to take responsibility for the terms. The termination is very important. Using the termination in the proper way. Case F. These two cases highlight the challenges and potential risk of managing large-scale charitable giving, underscoring the importance of careful consideration of donor intentions and effective communication between donors and recipients. Thank you for everyone listening.